In this alternate history, a $4 million book deal becomes the payment that brings the Supreme Court to its knees.
This story is fictional. It's based on real events, but everything beyond the known facts is speculation. Our goal is to explore an alternate timeline, not to rewrite history, but to imagine what might have been.
In July 2026, the Supreme Court released its annual financial disclosure reports. The documents revealed what many had long suspected, that several justices earned substantial income beyond their government salaries. Book deals, speaking arrangements, royalties from memoirs and legal commentaries. Under existing rules, none of it was prohibited. Ethics watchdog groups called it a transparency problem. Most Americans shrugged and moved on. But the disclosures contained one detail that didn't shrug off so easily. Justice Raymond Callaway, a 10-year veteran of the court, had reported a book of $4.2 million from a small imprint called Meridian Press Group. The imprint had no public profile, no catalog of note, no literary history worth mentioning, and yet it had paid a sitting Supreme Court justice more than most best-selling authors ever see in a lifetime. 3 weeks after the disclosures dropped, an investigative team at a major national outlet published what they called the paper trail. Meridian Press Group, they reported, was a shell company incorporated in Delaware and ultimately controlled by a holding fund linked to Garrison Capital, the investment firm owned by billionaire industrialist Leonard Harwick. Harwick had 2 cases pending before the Supreme Court at that exact moment. One involved environmental liability worth an estimated $9 billion. The other was a First Amendment challenge that, if decided in his favor, would gut a federal regulatory agency that had been investigating his companies for years. Justice Callaway had not recused himself from either case. The story detonated. Within 48 hours, every major network carried. Congressional leaders called for an emergency hearing. The White House said it was monitoring the situation. The Justice's office issued a statement calling the payment a legitimate literary advance and insisting there was no relationship between the publisher and any outside financial interest. Nobody believed it. The FBI opened a preliminary inquiry. It was not fast enough. 6 days after the story broke, the Supreme Court handed down its ruling in Harwick Environmental Partners versus United States. 5-4. Callaway voted with the majority. $9 billion in federal environmental liability erased, the largest favorable judicial outcome in Harwick's corporate history. The legal community did not wait for the FBI. 14 retired federal judges co-signed an open letter calling the ruling illegitimate. 3 state attorneys general announced their states would not enforce it. The Senate Majority Leader scheduled an impeachment inquiry, but privately told colleagues he did not have the votes to remove Callaway or any justice from the bench. The minority blocked every procedural move. Callaway refused to resign. The constitutional architecture clean answer for this. The Supreme Court is the final word on the law, but there is no institution above it to overrule a corrupt ruling made by a justice who will not leave. Congress could impeach, but lacked the will. The president could say nothing that carried legal weight. The states could defy, and 3 of them did. But defiance is not a remedy. It is the beginning of fracture. By the 3rd month, the situation had spread beyond Callaway. 2 other justices, facing renewed scrutiny from the disclosures, were found to have accepted travel paid for by entities with business before the court. Neither had disclosed the trips properly. Neither resigned. A 4th justice, the one who had written publicly calling for Callaway's recusal, received a credible threat against her family and stopped appearing in public. The court's public approval rating fell to 19%, the lowest ever recorded. International bodies took note. The European Court of Human Rights cited the crisis in 2 of its own opinions, observing that the United States federal judiciary could no longer be held as a model of judicial independence. 3 foreign governments facing U.S. sanctions formally appealed to the United Nations, arguing that a corrupted court system invalidated the legal basis of those sanctions. The State Department had no effective response. emergency legislation to expand the court, to establish an independent ethics tribunal with binding authority, to mandate recusal protocols. Every proposal died in committee or in procedural holds. The political system had generated the crisis and lacked any mechanism to resolve it. Protests outside the Supreme Court building grew through September. In late October, a confrontation between demonstrators and federal police left 11 people injured and the court plaza barricaded behind concrete barriers and chain-link fencing. The building went dark. The justices began working from undisclosed locations. No oral arguments were scheduled. No decisions issued. By December, the Supreme Court had not handed down a binding ruling in 61 days. Lower courts were in open conflict, issuing contradictory decisions on federal law with no higher authority available to settle them. Legal scholars began using a term they had previously reserved for failed states: judicial vacuum. Leonard Harwick was never charged. The preliminary FBI inquiry was quietly closed after a change in Justice Department leadership. Callaway remained on the bench, drawing his salary, protected by lifetime tenure and a Senate too divided to act. The book was never published. Meridian Press Group dissolved in November. Its registration records listed a P.O. box in Wilmington, Delaware, and a agent who had died in 2019. The country did not fall, but something essential had been cut away from it. The shared belief that there was a place above politics and above money where the law meant what it said. That belief did not come back. And without it, every ruling that followed was just one side winning, dressed up in black robes.
In this world, history went one way. But here, we ask what could have happened. If you want more alternate timelines and government what-ifs, subscribe, comment your theory, and stay tuned. This is State of What If.